Imagine this. You're out with 3 of your friends, just, walking down the street. To you, it's just another Tuesday. But under Philippine law, you might have just crossed a very serious line. We're diving into some legal codes today that show how just being in the wrong group can label you a criminal. Specifically, we're talking about the crime of brigandage.
And it's a really fascinating concept because it kind of flips our usual idea of crime on its head.
How so?
Well, normally the law waits for an act, right? You have to actually do something wrong.
Like steal a car or something.
Exactly. But with brigandage, the crime is the formation of the group itself. The law sees the group as a threat. Even before it acts, it's preemptive.
So let's get into that. What makes a group a band in the eyes of the law?
It starts with a magic number, the power of 4. Article 306 of the Revised Penal Code is very clear. You need at least 4 people.
Okay, 4 people, and I assume they have to be armed.
They do, but armed is a much wider net than you might think. We're not just talking about firearms here. Any deadly weapon counts. Knives, bats, even heavy tools, if the intent is to use them for violence.
And the location is a huge deal, too. People hear highway robbery and they think of, a major freeway.
But the law's definition of a Philippine highway is incredibly broad. It could be a bridge, a local street, a passageway.
Even a railway track, according to the source material.
That's right. And that's where Presidential Decree 532 comes in, because it adds another layer. The acts have to be indiscriminate.
What does that mean exactly? Indiscriminate?
It means the group isn't targeting a specific person they have a grudge against. They're preying on anyone who happens to be on that road. It's the randomness that a law sees as a major threat to public order.
And because of that threat, the penalties are, they're severe.
Extremely severe. If things escalate, if there's a kidnapping or a murder or worse, you're looking at reclusion perpetua.
Which is basically 20 to 40 years. A lifetime.
It is. And there's this legal trap, a kind of gotcha that everyone needs to know about. It involves firearms.
The unlicensed firearm presumption.
Yes. If just one member of that group of 4 has an unlicensed gun, the law automatically presumes the whole group are brigands.
Wow. So you might not even know your friend is carrying something illegal.
It doesn't matter. The law applies strict liability. Everyone in the group faces the maximum penalty. It's a powerful legal shortcut for prosecutors.
That brings up a key distinction then. What's the difference between this, brigandage, and robbery in a band? They sound so similar.
That's a great question. Think of it like this. Robbery in a band is committing a specific heist. You got caught robbing one particular bank with your crew.
Okay.
Brigandage is the crime of forming that professional heist crew in the first place with the general intent to go out and rob people. You could be found guilty without ever having successfully stolen a single thing.
The crime is the conspiracy, the organization itself.
Precisely. And the law's reach doesn't even stop there. It also goes after what it calls aiders and abettors.
And this is where it can get tricky for an average person, right?
It really can. If you give a band information, say, on where police patrols are, or you receive stolen goods from them,
yeah,
you're an accomplice.
And here's the kicker from what I read. The law presumes you knew they were a criminal band?
It does. The burden of proof shifts to you. You have to prove that you are completely unaware of their criminal nature, which is incredibly difficult to do.
It's a lot to process. The law is looking at associations, at intent. It's trying to stop crime before it even happens.
That's the whole philosophy behind it.
So, as we wrap up, here's a thought to leave everyone with. In our digital world, information moves in an instant. So where is the line between being a helpful member of the community and a legal accomplice? The next time you see an alert on social media for a police checkpoint or speed trap and you think about sharing it, just pause for a second. Ask yourself, are you just helping a neighbor avoid a ticket? Or are you potentially, technically providing information on police movements to someone the law is trying to catch? Something to think about.
Hey there. You ever notice how some crimes have these really specific, kind of old-fashioned names? Well, it's not just for flair. Those names point to some pretty unique legal ideas. Today, we're going to unpack one of the most interesting ones, the law of brigandage. And believe me, it is so much more than just a simple robbery.
All right, so let's jump right in with the big question. At what exact moment does a group of criminals cross that line? When do they stop being just a bunch of robbers and become what the law calls a band of brigands? It's a really cool legal puzzle, and the answer tells you a lot about what the law's actually trying to stop.
So here's how we're going to break it all down. First, we'll figure out what a brigand even is. Then we'll look at the legal blueprint. We're going to compare brigandage to regular robbery, check out a modern update to the law, see what happens if you help these guys, and finally, get to the bottom of why this law is even on the books.
Okay, first things first. What exactly is a brigand? Well, the first thing you've got to understand is that the law isn't just zeroing in on a single crime. No, it's looking at something way bigger, the organization itself.
And this right here gets straight to the heart of it. This law isn't really about punishing a theft that already happened. It's designed to be a shield. It's meant to stop organized criminal groups before they can even get off the ground and start threatening the public.
So, how does the law actually define what a brigand is? Well, for that, we have to look at the legal blueprint, the original recipe, if you will, which comes from Article 306 of the Revised Penal Code. This is where we get all the ingredients for the crime.
And the very first ingredient in that recipe is a magic number 4. That is the absolute minimum. You see, if you've got 3 armed people with a criminal plan, that's a huge problem for sure. But legally speaking, it's not brigandage. You've got to have at least 4.
It basically boils down to a 3-step test. Step 1, like we just said, you need at least 4 armed people. Step 2, they have to actually come together and form a band of robbers. And step 3, and this part is crucial, they have to have a very specific criminal purpose, which we're about to get into. Now, when the law says armed, what does that actually mean? You might immediately think of guns, right? But the legal definition is way, way broader. The case People versus De La Rosa made it super clear. Armed covers any deadly weapon. So we're talking knives, clubs, you name it. If it can be used to cause serious harm, it counts.
Okay, let's talk about their purpose. Article 306 lays out some very specific goals. It's not just any old crime. The group has to be formed with the intent to commit highway robbery, or to kidnap someone for ransom, or to achieve some other goal using force and violence. This is what really elevates them into this special category.
And this brings us to a really, really important distinction. How is brigandage different from what the law calls robbery in band? I mean, both involve a group of 4 or more people, right? Well, the answer, as we're about to see, is all about their long-term intent.
Let's break this down side by side. For robbery in band, the group's purpose is to pull off one particular robbery. For brigandage, it's more like a general campaign of crime. This difference is huge. For robbery, prosecutors have to prove the crime actually happened. But for brigandage, just proving the band formed with that criminal intent is enough. The analogy here makes it click. Robbery in band is like a one-off project team for a single heist. Brigandage is a full-blown, ongoing criminal business.
But laws don't just stay the same forever. The original idea of brigandage got a major update with Presidential Decree 532, which is also known as the Highway Robbery Act. And this law really shifted the focus in a big way.
You see, the original law was all about the criminal group itself, how they formed, what their goal was. But this new decree, it added a whole new layer. It started looking at the victims, or more accurately, the fact that there isn't one specific victim.
And honestly, you can't say it better than the court did in the landmark case People versus Puno. The modern crime of highway robbery, or brigandage, isn't about targeting a specific person or a specific truck. It's about outlaws preying indiscriminately on anyone and everyone. It's that randomness, that terrorizing of the general public, that really defines the crime now.
Of course, these groups don't just operate in a bubble. They need help. So naturally, the law has something to say about the people who give them that help. This is all covered in Article 307, and it makes being an accomplice a very serious crime.
The law is super specific about what it means to aid a brigand. You can't help them or protect them, you can't give them intel about where the police are, and you can't knowingly take any of the stuff they stole. And here's the kicker. The law often just presumes you knew what was going on, unless you can prove that you didn't.
So after going through all these details, the number of people, their weapons, their intent, even their helpers, we circle all the way back to the big question. Why? Why does the law go to all this trouble to define this one very specific crime?
This quote from a really old case, U.S. v. Dekusin, just says it all, perfectly. It is the core idea behind this entire law. The goal isn't to react after a crime has been committed. The goal is to be proactive, to stop these organized gangs before they can even get started.
And that's really our key takeaway here. A single robbery, that's a crime against one person or one family. But a band of brigands, that represents a crime against public order itself. By punishing the conspiracy, the very act of forming the group, the law is trying to cut off the threat of organized violence before it can grow and systematically terrorize everyone.
So I'll just leave you with this thought. The law of brigandage doesn't just punish the criminal act, it punishes the act of organizing to commit the crime. So what does that tell us about what society fears the most? Is it just losing our stuff, or is it the fear of order itself breaking down? Something to think about. Thanks for tuning in.
Welcome back to the deep dive. We are back at the table. The coffee is hot, and we were opening up a file today that, I have to be honest, when I first glanced at the title on the syllabus, I thought we were going to be reviewing an old Clint Eastwood script.
Chuckles. I can see that. It has a certain cinematic ring to it, doesn't it?
It really does. Or maybe analyzing the historical accuracy of a Zorro movie. The topic on the stack today is brigandage. And immediately, my brain goes to men in masks, riding horses through a dusty canyon, stopping a stagecoach, and, demanding the jewels from the aristocracy.
A classic image.
It feels very cinematic. It feels, well, archaic. But then I started actually reading through the source material you brought in, specifically Crimes Against Property, Syllabus 10, Chapter 2, and that romantic image fell apart pretty quickly.
As it usually does when you apply the cold, hard logic of the law to it.
Exactly. I realized that while the word brigandage sounds like something out of a 19th century novel, the legal reality, particularly in the Philippines, is incredibly serious, technically specific, and frankly, a little terrifying.
It is. The law is very concerned with how it looks at works of people.
That's the perfect way to frame it. While the terminology, brigandage, highway robbery, the band, might conjure up images of the Wild West in the Philippine legal context, we're dealing with a very rigid definition.
It's extremely rigid. We aren't just talking about stealing things on a road.
No.
We are talking about the anatomy of a criminal organization. We are talking about how the state identifies and neutralizes a specific type of chaos.
The anatomy of a band. I like that. That is our mission today.
It is. Our mission is to decode what legally constitutes a band of robbers.
Okay.
We're going to parse the incredibly fine line between simply committing a robbery as a group and the crime of actually being a brigand.
And that is a distinction I really struggled with during the prep. The idea that you can be punished for being something rather than just doing something.
It's a fundamental shift in perspective.
It feels counterintuitive to how we usually understand crime. You did the thing, you get punished for the thing.
It touches on the philosophy of proactive law enforcement. The state doesn't always want to wait for the victim to bleed before it acts.
Right. It wants to stop the potential for bleeding.
And to understand that, we are going to trace how this law evolved. We start with the classic definition in Article 306 of the Revised Penal Code, and then we move into the modern era with Presidential Decree number 532, which covers highway robbery.
And that shift is huge. I mean, the difference between the old code and the presidential decree, it changes the entire landscape of how these crimes are prosecuted.
It really does.
It changes who is a target and, crucially, where the crime can happen.
It redefines the geography of the crime, absolutely. The whole playing field is different.
So let's not waste any more time. Let's dive right in. I want to start with the basics. Article 306 of the Revised Penal Code. We're talking about the band. Now, in my head, a band is just a group of people. If I'm with two friends, we're a band of friends. But the law has a specific calculator out for this one, doesn't it?
It absolutely does. In the eyes of the law, numbers matter. You can have a conspiracy, you can have a partnership, you can have a trio of troublemakers.
Right.
But to be convicted of brigandage under Article 306, you need to hit the magic number.
And that number is?
4. To constitute a band, there must be at least 4 armed persons.
4.
Not 3. Not 3. If you have 3 people plotting to rob travelers, that is a different legal categorization. That might be conspiracy to commit robbery, or if you actually do it, it's robbery with aggravating circumstances.
So a different charge entirely.
Different charge. But the moment you add that 4th person and you are all armed, you cross the legal threshold. You become a band in the eyes of the law.
It's interesting that the law draws the line there. It feels a little arbitrary, but I assume there's a logic to it.
There is. It's about force multiplication. The law recognizes that group dynamics shift when you get to 4 people. A group of 3 is a small crew. A group of 4 is a squad.
Okay.
The psychological intimidation factor goes up. The ability to control a crowd, to surround a vehicle, it goes up. The tactical capability to ambush goes up.
So the threat level is just fundamentally different.
It is. So the law says, okay, once there are 4 of you, we are treating you as a distinct entity. You are now a band. And that comes with its own set of very serious consequences.
Okay, so 4 is the floor. If you have 3, you're just criminals. If you have 4, you're brigands, potentially.
Essentially, yes. If you meet the other criteria, which are just as important.
Right. The next criterion is the gear. The law says armed. Now, living in the 21st century, when I see armed in a legal text, I usually assume firearms.
That's the common assumption.
I'm thinking pistols, shotguns, assault rifles. But the source material you provided, specifically a case, I think it was People versus De La Rosa, seems to suggest the definition is much, much broader than that.
That is a crucial distinction, and one that defendants often get wrong. In People versus De La Rosa, the court had to interpret what armed actually meant. The defense likely argued, hey, we didn't have guns, so we weren't an armed band.
Which sounds like a reasonable argument in plain English. If you asked me on the street, I'd probably agree.
In plain English, maybe. But in legal English, absolutely not. The court was very clear. Armed covers arms and weapons in general. It does not necessarily mean firearms.
So let's paint a picture here. If 4 of us are walking down the highway carrying, say, bolos.
You are armed.
What about machetes?
Oh.
What about really heavy clubs? Or maybe just big, sharp sticks? I mean, where's the line?
Any deadly weapon counts. The test isn't about gunpowder. The test is about the capacity to inflict lethal harm or serious intimidation. If the weapon is capable of killing someone, and there are 4 of you holding them, you satisfy the armed requirement of the law.
So the law is looking at the effect on the victim, right? The potential for terror and harm.
Exactly. Imagine you are a traveler on a lonely road at night. Does it matter to you if the 4 men blocking your path have revolvers, or if they have 2-foot-long rusty machetes?
Honestly, the machetes might be scarier. There's something more visceral about it.
Right. The terror is the same. The threat to public order is the same. The capacity for violence is the key. So the law casts a wide net. If you are a group of 4 and you are holding things that can kill people, you are an armed band.
Okay, so we have the head count and a minimum of 4. We have the gear, any deadly weapon. Now comes the tricky part, the part that I found really intellectually stimulating in the notes, the intent.
The intent is everything. This is the heart of the crime.
Let's say we have 4 armed people. They are roaming the countryside. But let's say they are a group of rebels. Maybe they are political dissidents. They have guns. There are 4 of them, and they are definitely causing trouble. Are they brigands?
This is where we have to look at the specific purpose of the group. And the short answer, based on the legal precedents and the definition of the crime, is probably no.
Really? Why not? I mean, they're an armed group causing violence. To the average person, a rebel and a bandit look pretty similar when they're pointing a weapon at you.
They might look similar in action, but their legal intents, their why, are different. The source materials say it's a clear exclusion regarding what it calls a band of dissidents.
Explain that distinction. It feels like a fine line.
It is. If the purpose of the group is, for example, to destroy army installations by force and violence, if their goal is political, insurrectionary, or seditious, they cannot be convicted of brigandage.
Because brigandage is a specific flavor of crime.
Exactly. Brigandage is a crime against property. It is rooted in greed, in personal gain, or in terror for profit.
Okay.
If you are attacking a military base because you want to overthrow the government, you are a rebel. You are facing charges of rebellion, sedition, or treason. You are, legally speaking, an enemy of the state.
But if you are stopping a carriage to steal a necklace,
Then you are a brigand. You are an enemy of the public. Your motive is personal enrichment.
I see. It's the difference between fighting the power and preying on the people.
That is a very good way to put it. And the law actually lists 3 specific statutory purposes that define a band of brigands. The prosecution has to prove that the group was formed for one of these 3 reasons.
Okay, let's list them out. What are the 3 things this group must be trying to do to be called brigands?
First, they are formed to commit robbery in the highway.
And highway here, I recall a case note about that. It's not just a rural road.
Correct. That comes from U.S. versus Tanseco. Highway isn't just a country road or a dirt path in the province. It includes city streets.
So 4 armed guys on a city street in Manila planning mugging could theoretically fall into this.
Theoretically, yes, if they meet the other criteria of organization. The location doesn't save them just because it's paved and has streetlights. Any public thoroughfare.
Okay. That's a much broader definition than I expected. Purpose number 2.
The second purpose is to kidnap persons for extortion or ransom.
The classic kidnap for ransom gangs.
Mm-hmm.
This one is pretty straightforward.
Purely profit-driven. They aren't trying to make a political statement. They are trying to make a payday by taking a person.
And the third purpose, this one felt a bit more vague to me.
The third is a catch-all phrase. To attain any other purpose by means of force and violence.
Any other purpose by means of force and violence. That sounds incredibly broad. That sounds like it could trap the rebels again if you interpret it loosely.
It sounds broad, but in legal interpretation, we often use the principle of ejusdem generis,
Meaning
of the same kind. It is usually interpreted within the context of the first two purposes, robbery and kidnapping for ransom.
so it has to be something similar in nature.
Exactly. It implies other predatory acts against the public for gain or terror. It generally won't drag the political rebels back in unless their rebellion is just a cover for looting.
Right. If you claim to be a rebel, but you're really just stealing cows and selling them, the court is going to see through that.
Precisely. If your political action looks suspiciously like just getting rich off stolen goods, the dissident defense falls apart very quickly.
This brings me to a concept that I found fascinating in the notes. We talked a bit about this in the intro, the difference between the crime of being and the crime of doing.
Yes, this is a very important distinction.
Usually in law, or at least in my understanding of it, you get arrested because you did something. You stole the car, you punched the guy, you forged the check. There's a concrete act.
An actus reus.
Right. But brigandage seems to criminalize the organization itself, the mere existence of the group.
This is one of the most unique and aggressive aspects of this crime. It is a status offense in many ways. Let's look at the concept of membership. Suppose you are hanging out with a group of bad guys. You haven't personally robbed anyone yet. Can you be convicted just for being there?
My gut says, maybe. Guilt by association, it feels like a slippery slope.
It is nuanced. The case U.S. versus Canada establishes that mere membership in an armed band is not sufficient for brigandage.
Okay, so just hanging out isn't enough. I can breathe a sigh of relief.
Well, don't exhale just yet. The prosecution has a burden of proof. They must prove that the band was organized for the specific purposes listed in Article 306.
So intent again?
Always intent. They have to show that this club you belong to isn't just a hunting party or a neighborhood watch gone wrong. It was built to rob and kidnap.
So they have to prove the corporate mission of the group, so to speak.
Exactly. But, and here's the but that catches a lot of people, there is a trap door built into the law.
I saw this in the notes, the presumption of guilt. This part is wild.
Ah, yes. The trap door. This is where the law gets very, very aggressive. It's the last paragraph of Article 306.
Walk us through this scenario. This is important for anyone listening to understand.
Imagine you are with a group. The court determines it is a lawless band. You are roaming around. And crucially, you or members of your group possess unlicensed firearms.
Unlicensed. That's the key adjective, not just any firearm.
That is the trigger. If you are in a lawless band and there are unlicensed firearms involved, the law creates a presumption of brigandage.
So the burden of proof shifts. Normally it's on the prosecution.
It flips completely. The possession of an unlicensed firearm by any member of the band creates a legal presumption that all of you are highway robbers or brigands.
Wow. Pause on that.
Yeah.
Any member. Not just the person holding the gun.
Any member.
So if I'm in a group of 4, and I'm just holding a stick, I'm the stick guy. But my buddy next to me, unbeknownst to me, or maybe it's suspected, has an unlicensed pistol tucked into his waistband.
Right.
We get stopped. He gets searched. They find the gun.
If the context suggests you are a lawless band out on the highway, you are all presumed to be brigands.
Even though I didn't have the gun. Even though I was just holding a piece of wood.
Even though you didn't have the gun, the law imputes the criminal nature of the weapon to the entire group. It assumes you knew and you were all in it together.
And the consequences of that presumption.
It's severe. This situation results in the imposition of the penalty in the maximum period.
That is incredibly harsh. It feels like it violates the innocent until proven guilty idea.
It does feel that way, but look at it from the perspective of the state. The state is saying, if you are roaming around in a lawless pack and you have illegal guns, we aren't going to wait for you to hurt someone.
Right.
We aren't going to wait for the body count. We assume, by your very formation and equipment, that you are there to do harm.
It's preemptive. It's the Minority Report of property crime.
What?
Catching you before the crime happens.
It is entirely preemptive. The logic is that honest people don't roam in packs with illegal weapons. Therefore, if you are doing so, you are a threat that needs to be neutralized immediately.
And this leads to the confusion you mentioned earlier, the difference between brigandage and robbery and band.
Right, because robbery and band sounds exactly like brigandage. It's a band robbing people. It's a classic legal tripwire.
Linguistically, they are twins. How does the law separate them?
They are distinct species legally. We look to the case U.S. versus Feliciano to draw the line. Think of robbery and band as a specific event. The purpose of the group in that moment is to commit a particular robbery.
Like, let's go rob that specific bank on Main Street at 2:00 p.m. It's a one-off mission.
Exactly, it's a heist. To convict someone of robbery and band, you usually must prove that the robbery actually happened, or at least that the specific attempt was made.
Okay.
If you just conspire to rob the bank but get caught before you do it, mere conspiracy to commit robbery is usually not punishable unless there's a specific law covering it.
So robbery and band focuses on the act, the event, the heist.
Correct. Brigandage focuses on the formation, the ongoing existence of the group.
Not the act.
Not necessarily. In brigandage, the crime is the formation of the band itself. As per U.S. versus DeCusin, the object of the law is to prevent the formation of the band.
So you don't need to prove an actual robbery occurred.
You do not. That is the aha moment. In brigandage, the crime is existing as a group with that criminal intent. You don't actually have to succeed in robbing anyone.
That is wild. So if the police catch you and can prove that your group exists for the purpose of highway robbery or kidnapping, you are guilty of brigandage, even if you haven't stolen a single peso yet.
Precisely. The danger you pose to society by simply existing and roaming the country is what the law is punishing. You are an outlaw organization. You have stepped outside the social contract just by forming this group.
But that raises a massive question of evidence. We just said you don't need an act of robbery to be convicted. But if they don't have to actually rob someone to be caught, how does a prosecutor prove they wanted to?
Right.
You can't open up their skulls and read their minds. How do you prove intent if the act didn't happen?
That is the challenge of Section 3 of our discussion, proving the purpose. You are right, you can't read minds. So the courts look at history.
History, the group's history.
The resume of the band, so to speak. The source cites a key case here, People versus La Pareda.
Tell us about that case. How did they prove intent?
In La Pareda, the court had to determine if a group was a band of brigands. The defense probably argued, we're just hanging out, we haven't done anything.
The classic defense.
But the court looked at what the group had done in the past. They found evidence of kidnapping and looting done on 2 previous occasions by members of this same group.
So they used past crimes to prove the purpose of the current band.
Exactly. They argued that these previous acts proved the intent and the nature of the organization. They said, effectively, look at what they did last week. Look at what they did last month. That is why they are gathered here today. It establishes the pattern of conduct.
We know what you are because we know what you've done.
Correct. It defines the profession of the group. They are not farmers or fishermen who happen to be together. They are professional brigands.
And there's also a geographical element to this proof, right? The locus of the crime. I saw that in the notes.
Yes. The law says the band must have gone upon the highway or roamed the country for that purpose. It implies mobility.
Roaming the country.
Yeah.
That phrase keeps coming up. It sounds so old-fashioned.
It does, but it's important legally. Brigandage isn't usually a group of guys sitting in a basement planning a crime. That might be a conspiracy.
Right.
Brigandage implies a group out in the world, moving, looking for victims, a mobile threat.
It really brings back that cinematic image of the bandits on the road, the idea of the predator on the prowl.
It does, but again, the danger is real. A mobile, armed group is hard to police. They can strike anywhere, they terrify a community because they're unpredictable, and that's what the law is trying to stop.
Now, everything we've talked about so far, Article 306, the magic number 4, the definition of armed, all of that is rooted in the revised penal code. That's the old school law.
The foundation.
But laws evolve. And in the Philippines, a major evolution happened in the 1970s.
This is the modern shift. PD Nome 532.
Presidential Decree Number 532, also known as the Anti-Piracy and Anti-Highway Robbery Law of 1974.
Correct. A very significant piece of legislation.
Why was this necessary? Did the old law not cover enough? Was Article 306 getting too dusty?
Well, the context of the 1970s is important. It was a time of martial law. a time of heightened concern over public order. But, strictly looking at the text, the decree sought to modify and repeal pertinent provisions to make the law more robust against modern threats.
So it's an update.
It updates the software of the law, so to speak. It broadens and clarifies the definitions to cover situations the old code might have struggled with.
Let's look at the updates. Start with the definition of highway. Under the old code, we had some case law saying it included city streets. What does PD 532 say?
PD 532 is very explicit and very, very broad. A Philippine highway under this decree isn't just a dirt road. It includes roads, streets, passages, bridges, but it also includes railways and railroads.
So if you were on a train, you were on a highway in the eyes of this law.
Correct. Essentially, any infrastructure used for the movement of persons, goods, or vehicles. If it is an artery of commerce or travel, it is protected under this law. It's a very expansive view.
Okay, that's a big change. And PD 532 breaks the crime down into two specific modes.
Yes, it simplifies the purpose part. Mode 1 is the seizure of persons. This covers kidnapping for ransom, extortion, or other unlawful purposes on a highway.
And Mode 2.
Mode 2 is the taking of property, robbery, by violence, intimidation, or force upon things committed on a highway.
Okay, playing devil's advocate here, that just sounds like robbery again. I robbed someone on a street. Why do I need a special presidential decree for that? Why isn't that just robbery under the old code?
This is the most important part of today's deep dive. If you take one thing away from this episode, it should be this. The distinction between simple robbery on a street and highway robbery under PD 532 lies in one specific, crucial concept.
The aha moment you highlighted in the notes.
The indiscriminate requirement.
Let's unpack this, because this seems to be the thing that saves a regular mugger from being charged with this very serious crime of highway robbery under this specific decree.
This is the most critical distinction in modern case law, and it comes from a landmark case, People versus Puno. The question before the Supreme Court was, does a regular mugging on a street count as highway robbery under PD 532?
And the court said,
They said, absolutely not.
why not? I mean, it happened on a street, which you just said is a highway. It was a robbery. The pieces seem to fit.
They seem to, but they're missing that key ingredient. PD 532 applies to acts committed indiscriminately against any person.
Indiscriminately, that is a heavy word. Let's break it down with examples. That's the best way to understand this.
Let me give you two scenarios to illustrate. Scenario A. You hate your neighbor, John.
Poor John. Always gets picked on in these hypotheticals.
Poor John. You know, John walks down Rysel Avenue every Friday at 5 p.m. You get your friends, you wait for him, and when he walks by, you grab him and take his wallet.
Okay. That's robbery. It happened on a highway, a city street.
That is simple robbery under the revised penal code. It is a crime against a specific person. You targeted John. You had a motive related to him specifically. The victim was predetermined.
Now give me scenario B.
Scenario B, you and your group stand on a bridge or a dark stretch of the highway. You don't care who comes by. You are just waiting for the first nice car. Or the first pedestrian who looks like they have money. Or the first delivery truck. You stop them and rob them.
That's indiscriminate. The victim could be anyone.
That is highway robbery under PD 532.
Because the victim wasn't predetermined. They were a target of opportunity. You weren't attacking John, you were attacking the public.
That is fascinating. So it's about being an outlaw against society versus committing a crime against a specific individual.
Exactly. The source material uses that exact term, outlaw. PD 532 punishes acts perpetrated by outlaws indiscriminately against any person. It elevates the crime because acts of random terror disrupt the freedom of movement for everyone.
Right. If I rob John, John is scared. Maybe John's family is scared. But if I rob random cars on the highway, then everyone is scared. Everyone who drives that road is terrified. It paralyzes commerce. It paralyzes travel. It is a direct attack on the state's ability to maintain order and public safety.
That makes total sense. It's a crime against public order and safety, not just property. The victim isn't just the person who lost their wallet. It's everyone who now has to be afraid.
Precisely. The crime has a much wider blast radius of fear.
So if you are caught doing this indiscriminate highway robbery, what are we looking at in terms of penalties? The scales of justice usually weigh heavier when the public is the victim.
They certainly do. Under PD 532, the penalties are severe. They are designed to be a powerful deterrent.
Break it down for us. What's the range?
For simple highway robbery, just the taking of property without major injury, you are looking at reclusion temporal in its minimum period.
Which is Translate that from legal speak into years for us.
Roughly 12 to 14 years as a starting point, so over a decade.
That's a decade plus, just
Right.
for the theft. No one even has to get hurt.
Yes. Now, if the robbery is accompanied by physical injuries, the penalty jumps to reclusion temporal in the medium to maximum periods.
So we are pushing towards 20 years.
Correct. And if it gets worse,
How much worse could it get?
if the highway robbery involves kidnapping, murder, homicide, or rape committed as a result or on the occasion of the robbery, the penalty is reclusion perpetua.
Life imprisonment.
Essentially, yes. Imprisonment for 20 to 40 years, usually without the possibility of parole until 30 years are served. The source note mentions that the death penalty was not specifically restored by Republic Act number 7659 for this particular section, so reclusion perpetua is the ceiling.
But that is a lifetime consequence.
It is. It really underscores how seriously the state takes the safety of travel. They are willing to lock you away forever if you turn the highways into a hunting ground.
Absolutely. Now, we've talked about the brigands, the robbers, the main guys holding the weapons. But criminal organizations are rarely just the guys on the front line.
No, there's always a support network, the logistics.
The logistics. The people who hide them, feed them, buy their stolen goods. The ecosystem that allows them to operate.
The accomplices.
Right. Section 6 of our outline covers this, Article 307 of the Revised Penal Code, and Section 4 of PD 532. This is about aiding and abetting.
This is a very dangerous area for anyone associated with these groups. The law is very aggressive in defining who is complicit. It casts a very wide net.
What are the deadly sins of assistance here? What gets you in trouble?
There are three main categories of acts that make you liable as an accomplice. First is aiding or protecting. This means providing shelter, food, or any kind of material support to the band.
So letting them crash in your barn, giving them rice and supplies.
Exactly. You are sustaining the threat. Second is intelligence, giving the brigands information about the movements of police or peace officers.
Hey, the cops are setting up a checkpoint at the bridge. You should take the back road.
If you send that text, you are aiding brigandage. You are acting as their eyes and ears. You are actively helping them evade justice.
You are the lookout or the informant. And the third category.
Fencing. Acquiring or receiving property taken by the brigands. If you buy the stolen jewelry or the hijacked cargo, you are part of the ecosystem. You create the market for their crime.
Now here's the question I think a lot of people would ask. Can an accomplice claim ignorance? Oh, I didn't know they were brigands. I thought they were just enthusiastic collectors of other people's stuff.
Chuckles. It is a common offense, but the law is one step ahead. It is very, very difficult to claim ignorance here.
Why is that? How does the law counter that defense?
Because of the presumptions built into the law, just like with the unlicensed firearms. Under Article 307, if you do any of those specified acts like warning them about the police, you are presumed to have performed them knowingly.
So the act itself implies the knowledge. It's self-evident.
Exactly. Why would you warn a group about police movements if you didn't know they were hiding from the police? Honest people typically want the police around. If you are helping someone avoid them, the law assumes you know why.
That makes perfect sense. Plausible deniability is very low.
Very low. And under PD 532, it's even more explicit. Acts of aiding or protecting are presumed to be performed knowingly unless the contrary is proven.
So the burden of proof shifts to the accused again. You have to prove you didn't know. You have to prove your own innocence.
Correct. You have to prove your innocence regarding your intent, which is very hard to do when you have been caught hiding bandits in your house.
And how are these people punished? Are they treated the same as the guys with the guns?
Not exactly the same, but still severely. Under PD 532, these people are classified as accomplices. Generally, an accomplice is punished 1 degree lower than the principal offender.
So if the brigand gets reclusion temporal,
The accomplice gets a step down from that, which is prison mayor in its maximum period to reclusion temporal in its medium period. It is still significant prison time. Years.
it creates a legal quarantine around the band. It makes it dangerous for anyone in the community to interact with them.
That is the goal, to isolate the band. If no one can feed them, hide them, or buy their stolen goods without facing prison, the band cannot survive. It starves the organization of its support.
So we've traveled quite a distance here today. We started with the idea of a four-man band under Article 306, that rigid, almost formulaic requirement of 4 armed people.
Right. And we looked at the intent, that it can't be political rebellion, it has to be criminal profit.
Then we moved through the presumption of brigandage regarding unlicensed firearms,
Yeah.
and that vital distinction that brigandage is the crime of formation, not just the act of robbery.
A crime of being, not just doing.
Exactly. And then we landed on the modern reality of PD 532. The highway is suddenly everywhere, trains, streets, bridges, and the defining characteristic is indiscriminate targeting.
That shift from robbing John to robbing whoever comes along is the hinge upon which the modern law turns. It's a difference between a personal crime and a public terror.
It really paints a picture of how the state views chaos.
That is the central theme, isn't it? The state's fundamental desire to crush organized chaos. Whether it's the formation of a band in the countryside or the random terrorizing of highways in the city, the law treats these as distinct from ordinary crimes. They are threats to the very fabric of public order and travel.
It's not just about losing your wallet. It's about losing your sense of safety in public spaces.
Yeah.
The freedom to move without fear.
Exactly, the freedom of the road.
So, here is a thought to leave you with. We talked about that indiscriminate requirement. The idea that randomness makes the crime worse in the eyes of the law.
It absolutely does.
Next time you hear about a robbery on the news or you see a report on your feed, ask yourself this. Was it personal? Did the robber know the victim? Was there a specific target? Or was the victim just in the wrong place at the wrong time?
A crucial question.
Because in the eyes of the law, that element of random chance that it could have been anyone factor is what turns a criminal into an outlaw and turns a robbery into a crime against the highway itself.
And that random chance makes a massive difference in how the criminal is judged and ultimately punished.
Thanks for joining us on this deep dive. Stay safe on the highways, everyone.
Stay safe.
Welcome to the debate. Today we're stepping away from abstract theory and getting right onto the dusty roads and maybe the gridlock city streets of the Filipino legal landscape. We're dissecting a concept that at first glance sounds like it belongs in a history book, but is actually a very live wire in our revised penal code: brigandage.
It is. It's a fascinating and, I would argue, an incredibly high-stakes area of law because it really deals with the psychology of the group. We're looking at two main sources here: Article 306 of the Revised Penal Code and then Presidential Decree No. 532, which is the anti-highway robbery law from 1974.
Exactly. And the central tension we're exploring today is, well, it's fundamental to how we define criminality. The question is this: does the crime of brigandage lie in the act of robbery itself, or does it lie merely in the formation of a band with the intent to commit those acts? At what point does a group of criminals cross that line from being simple conspirators to being a band of brigands?
It's the difference between punishing what people do versus punishing what they have organized themselves to be. And that distinction carries massive legal weight, especially when we start talking about the indiscriminate nature of the crime.
So my position is that the law, specifically Article 306, is designed as a preventative weapon. Brigandage is a crime of formation and potentiality. The law can't wait for a tragedy to occur. The very existence of a lawless, armed band roaming the country is, in itself, the injury to society.
And I'll take the opposing view. I believe that under the modern framework, and here I'm looking specifically at Presidential Decree 532 and the Supreme Court's landmark ruling in People v. Puno, we have to be much stricter, much more precise. True brigandage requires indiscriminate acts against the public. If you plan a specific crime against a specific person, you are a robber, yes, but you are not a brigand. And that distinction matters because the penalties are, well, they're life-altering.
Let's get into the heart of it then. My stance is rooted in this idea that public safety requires preemptive action. Brigandage is a unique crime. It doesn't target a specific result, like a stolen wallet. It targets the threat to public tranquility. If you look at the early jurisprudence, particularly a case called U.S. versus Dukusin, the court was very clear about the object of the law.
And what was that specifically? What was the court getting at?
The object is to prevent the formation of a band of robbers. The court essentially said, we don't need to wait for the band to strike. The danger is the organization itself. Under Article 306, the crime is committed when at least 4 armed persons form a band for the purpose of robbery, kidnapping, or attaining goals by force. The text itself highlights that the mere act of forming a band is punishable.
I understand that. Prevention is a noble goal, of course, but we're talking about criminal liability. You're criminalizing the setup before the payoff.
Precisely, and for good reason. I mean, society implies that if you have 4 people heavily armed roaming the countryside or the city, the terror is already inflicted, the community is paralyzed by their presence. The law even goes a step further on evidence to support this preventative stance. If members of a lawless band are found with unlicensed firearms, a presumption of brigandage arises automatically. The law assumes you're not out there for a picnic.
I see why you think that, and historically, sure, that was the intent when the law was drafted to combat post-war lawlessness. But I just don't think we can apply that broad brush today without looking at the specific nature of the acts. The law demands precision. Brigandage is a label that's often misapplied to what are, at the end of the day, standard crimes.
But standard crimes don't involve roaming bands of armed men.
They might involve a group, though. My position rests on the evolution of this law through PD 532 and that People versus Puno ruling from '93. The definition has narrowed significantly. The Supreme Court clarified that for a crime to be highway robbery or brigandage under this decree, it must be committed indiscriminately against any person.
We will get to the indiscriminate argument because that is where the real friction lies. But I worry it creates a loophole that just swallows the rule.
It's not a loophole, it's a safeguard against overpenalization. Look, if a group plans a specific heist against a predetermined victim, say they want to rob a specific bank manager on his way home, they are not brigands in the legal sense. They are robbers. Brigandage implies an outlaw status where the victim could be anyone. And furthermore, if we cite U.S. versus Canada, mere membership in an armed band isn't enough without proof that the band was organized for the specific purposes in the code. You can't just arrest 4 people standing together with weapons and call it brigandage.
I think we're dancing around the definition of the band itself, which is really our first core point of debate. This isn't just a casual term. Under the law, a band is strictly defined: 4 or more armed persons. And I want to be clear about what armed means, because some people might be picturing high-powered rifles.
Right, it doesn't have to be an armory.
No, not at all. In People versus De La Rosa, the court held that armed covers any deadly weapon. It doesn't have to be an M16. Bolos, knives, clubs. If 4 people gather with these, they create the intimidation the law seeks to punish. It's the collective presence of the weaponry that's the force multiplier. It turns individuals into a single entity of force.
That's technically true about the weapons. The law is agnostic about the type of lethality. But I want to challenge the universality of that band definition. Just because you have 4 armed people doesn't automatically mean you have a band of brigands. We have to look at the dissident exception.
You're referring to political crimes.
Correct. And this is a crucial distinction in the Philippine context. Citing the case of Reyes, a band of dissidents or rebels whose purpose is, say, destroying army installations or fighting the government, they cannot be convicted of brigandage.
Explain the rationale there. Because to a layperson, a man with a gun is a man with a gun.
The rationale is the specific intent. A rebel is not a band of robbers. Their purpose is political. It's ideological, not pecuniary. They aren't there to steal or kidnap for ransom in the context of a common crime. They're there to overthrow or challenge authority. The law treats that as rebellion or sedition, not brigandage.
That's a fair legal distinction, though I'd argue that to the person facing the gun, the political motivation of the shooter offers very little comfort. But okay, the law does distinguish them. One attempts to overthrow the state, the other parasitizes the community. But let's look at the purpose when it's not political. You said earlier mere membership isn't enough. I disagree with the implication that we need to catch them in the act. The purpose can be inferred.
Inferred from what? That sounds like a very slippery slope.
From context, from the environment. If you have 4 armed men roaming a highway, the presumption of intent is strong. The law doesn't require us to read minds, it allows us to read circumstances. But this leads to our second point, and probably the most common point of confusion for law students, distinguishing robbery in band from brigandage.
This is absolutely the most common confusion. People hear robbery and band and they think brigandage. They sound identical, but legally they are distinct species.
They are, and the key differentiator is the scope of intent. In brigandage, the purpose is general. The band exists to roam the highways or the country. Again, U.S. versus Dekusin is the authority here. If the band went upon the highway or roamed for that purpose, the crime is brigandage. I don't need to prove they actually robbed anyone. The mere formation for that general purpose is sufficient. It's a crime of lifestyle, not just a single event.
That is a compelling argument for the prosecution, I'll grant you. But then you have to consider U.S. versus Feliciano. This case sharpens the line significantly. If a group forms to commit only a particular robbery, the offense is not brigandage, it is robbery in band.
That seems like splitting hairs. If I form a group to rob a bank, am I not a brigand?
No, you're not, and it's not hair-splitting, it's about the criminal mindset. If I get 3 friends together to rob one specific convenience store and we go home afterwards, we're not brigands, we're conspirators in a robbery. Brigandage implies a career. It implies a state of outlawry where the band exists to prey on the public indefinitely. The prosecution has to prove the group intended to operate as career outlaws, not just a one-time conspiracy.
I can concede that a one-off event might be different. But how do you prove career intent before they commit a dozen crimes? We shouldn't have to wait for a rap sheet to grow. This is where a case like People versus Laporta comes in. The court ruled that previous activities can be used to prove the purpose of the band. If they kidnapped and looted on 2 previous occasions, we can use those past acts to stamp the current formation as brigandage. We blend the past into the proof of the present. It's about establishing a pattern.
That helps your case for established gangs. Certainly, past acts illustrate present intent. But let's move to where the rubber meets the road, literally. We need to talk about the highway and this concept of indiscriminate acts under PD 532. This is where the modern conflict really lies, and where I believe your preventive interpretation starts to fall apart.
I disagree. The definition of highway is much broader than people think. It's not just some provincial dirt road. Citing U.S. versus Tenseco, the term highway includes city streets, railways, bridges. The law protects all movement of persons and goods. If you're moving goods through Manila, you are on a highway in the eyes of the law. The venue is ubiquitous.
I agree with the geography. A street in Manila is a highway, sure. But I disagree with the application of the law on that geography. You're relying on the setting. I'm relying on the nature of the attack. I'm going back to People versus Puno. This is the critical limitation on PD 532. The Supreme Court held that acts constitute highway robbery brigandage only if they are committed indiscriminately.
Let's clarify that for everyone listening. When you say indiscriminately, you're not talking about the level of violence.
Correct. I mean, the victim selection, indiscriminate means the victim is chosen by chance or opportunity, not by design. If a group waits on a dark stretch of road and stops the first car that comes along, that is indiscriminate. That is brigandage. But, as the court ruled in Puno, if they wait on that same road specifically for their rival's car because they plan to rob him, that is not highway robbery under PD 532. It's simple robbery that just happened to be committed on a highway.
I find that interpretation incredibly risky. You're essentially saying that if criminals are smart enough to pick a target beforehand, they escape the harsher penalties of brigandage laws. It just weakens the protection of the highways. The highway should be a sanctuary for movement. Whether I'm targeted specifically or randomly, the violation of the peace is the same. The terror felt by other motorists is the same.
But the penalties are not the same, and that is exactly why we need the distinction. PD 532 carries the penalty of reclusion perpetua in some cases. For our audience, that's imprisonment for at least 20 years up to 40 years. It is effectively a life sentence. We cannot be handing out life imprisonment for what should be a standard robbery charge just because it happened on asphalt instead of in a house. The indiscriminate element is the controlling standard because it captures the true essence of brigandage, terrorizing the public at large, not just a private enemy.
It sounds like you're protecting the accused from the weight of the law, whereas I'm looking at the network that supports them. And this brings us to aiding and abetting. Brigands don't exist in a vacuum. They need food, information, shelter. Article 307 is very harsh, and rightly so.
It is incredibly harsh. It borders on draconian.
It punishes those who aid the band, give information on police movements, or receive stolen property. And here's the kicker. The law presumes these acts are done knowingly. The last paragraph of Article 307 states that if you're caught fencing goods for a known band, the law presumes you knew they were brigands. You don't get to play dumb.
That presumption of knowledge is terrifying from a civil liberties perspective. However, I have to point out that PD 532 actually modified this. Under Section 4 of that decree, those who aid or protect highway robbers are considered accomplices. This means they're punished 1 degree lower than the principals. The modern decree recognized that maybe we shouldn't treat the person who supplied rice the same as the gunman.
But the presumption remains effective in establishing the link. The law is trying to break the supply chain. If you cut off the information and the ability to sell stolen goods, the band starves. The presumption is necessary because proving a state of mind, proving that I knew you were a brigand, is almost impossible without a confession.
I just worry about the implication of guilt without direct proof of intent. If a farmer gives food to armed men because he's terrified, does the law presume he's an abetter?
The law usually requires the act to be aiding and abetting, which implies some level of voluntary assistance. But I grant you, the line can be blurry. Still, we have to look at the severity of the crime itself. We're talking about severe penalties because the crime destroys the social fabric. Under PD 532, if the highway robbery results in kidnapping for ransom or murder, the penalty is reclusion perpetua.
And just a technical correction, it's important to note that while the death penalty was discussed in the past, Republic Act 7659 did not restore it for this specific section. But reclusion perpetua, that 20 to 40-year stretch, is massive. This high severity is exactly why I insist on the strict indiscriminate requirement. You cannot lock someone away for 40 years for a simple robbery just because of a venue technicality. The punishment has to fit the nature of the crime, not just its location.
And I would argue the punishment fits the terror. When you step onto a public highway, you entrust your safety to the state. A band that violates that trust, that turns a street into a trap, has committed a crime against all of society, not just the victim. That is why the penalties are high. That is why the definitions in Article 306 are broad, to deter the formation of these groups before the first shot is even fired.
But deterrence shouldn't come at the cost of legal accuracy. If we blur the lines between a planned heist and brigandage, we dilute the meaning of the law. We end up treating a scalpel like a hammer.
We're nearing the end of our time, so let's summarize where we stand. I maintain that brigandage laws are essential preventive tools. The formation of armed bands specifically to roam and terrorize is a distinct threat. Whether we look at Article 306 or PD 532, the law exists to secure the peace of the highways. We shouldn't get so bogged down in whether the victim was chosen by lot or by name that we forget the terror of the act itself.
And I'll conclude that while the threat is real, legal precision is paramount. We must distinguish between robbery and band, a specific crime, and brigandage, which is a state of outlawry. Without that element of indiscriminate targeting as established in People v. Puno, the label brigand is misapplied. We cannot let the fear of crime push us to over-penalize acts that fall under other statutes.
It's a clash between the need for order and the need for precise justice.
It always is. And as our legal system evolves, that line continues to shift.
We also reflected on how the definition of highway includes city streets, which really brings us this discussion right to our doorsteps. It affects every citizen's understanding of safety.
Indeed. It forces us to ask, is it better to punish the formation of a threat or only the execution of the crime?
A question we will leave with you. Thank you for joining this intellectual exchange.
Until next time.